Hi everyone, I'm Linda Loveland here with Jake Parker, General Counsel for North Carolina Farm Bureau. And you know that what that means? That means we are talking legal ease. I don't know if this is easy or not.
There's lots of legal. Yes.
There's lots of legal
law,
involved,
lots of legal.
not a lot of ease. But we're talking about actually suing the Department of Labor. You're suing the federal government.
Yes, North Carolina Farm Bureau and a couple of our farmer members filed a lawsuit challenging a U.S. Department of Labor rule relating to the H2A program back on Friday the 13th.
What a day.
Yeah, it was. Yeah.
So simply put, so why the lawsuit? What does it? I know that it involves a rule that the government passed that we're not happy with and trying to change it.
Sure. The back up to 1986, when Congress passed what's called the Immigration Reform and Control Act, they created the H2A Agriculture Guest Worker Program, which allows farmers to bring H2A workers, that's what we call them, but foreign guest workers into the country. And the purpose behind the law was to address situations where farmers couldn't find enough U.S. workers to work their fields primarily.
Labor, a very, very big issue.
Huge issue. And part of what the Department of Labor is supposed to do in that program, they share joint responsibility with the Justice Department, the United States Justice Department, and the Department of Homeland Security. And the Department of Labor's responsibility in there is to certify that the workers who are coming in are not going to adversely affect the wages or working conditions of domestic workers. And so that's the kind of overarching background. Over the years, there's been a lot of litigation and a lot of rulemaking relating to that rule, but primarily to what we call the AWR, or the Adverse Effect Wage Rate. This is not that. What the department did is, based on concerns they were hearing from other groups, not us, that farmers were not treating workers correctly. We completely disagree with that. I think the vast majority of farmers in the country treat their workers well because their workers help them run their businesses.
They depend on them.
Why would they treat them poorly? But there's this narrative out there that that's the case, and so the department bought into that, and they developed a rule that's called, we call it the Worker Protection Rule. And the idea behind it was they needed to give workers more self-organizing rights that are typically given to union employees to collectively bargain with their employers, to engage in concerted action, which is coordinated activity to express their needs to their employers. So that's what the new rule does. It was promulgated, big legal term. It was issued on April 29th of this year.
And the issue of this, so that gives rights to migrant workers coming in, essentially the right to unionize, whereas U.S. workers don't have that right?
That's not exactly.
Or how is that?
Yeah, that's not exactly right, but they give the foreign workers these collective bargaining rights. The workers who work alongside them, they are engaged, the legal term is corresponding employment, but it's essentially the domestic workers that are with them are treated the same way. You can't treat them differently is what the law says. But it gives them all these collective bargaining rights. But what's important about it, Linda, is federal labor law, specifically the National Labor Relations Act, which was adopted back in the 1930s, provides that scheme for union and management issues. And it allows for workers to elect to affiliate with a union. But agriculture workers are exempt from the law. Congress, when they first drafted it, exempted agricultural workers from that law. So in our view, the states are responsible for regulating that, and many states have taken different approaches. California has a national labor relations style law where they have a California Agriculture Labor Relations Board, and they give workers in California that right to organize. In North Carolina, we take the opposite approach, which is called right to work. Excuse me. And so the right to work law allows for people to pick and choose. If a farmer wants to allow unionization on their farm, they can. If they don't want to, they can also take that right, or they can take that choice. But what the new rule does is it says to states like North Carolina, we get to say what your labor law is now. And they use immigration law to do it, not the National Labor Relations Act. So they're essentially trying to do an end run around a federally adopted statute. That's Congress's job, not the Department of Labor's.
So they're overreaching.
Exactly.
Is what that it sounds to. Okay, so I know there were some other states who went in a lawsuit earlier, so they are exempt from this. There's been an injunction for certain states,
Correct.
and there are several states that obviously we don't have an injunction. That's why we are filing this lawsuit. So
That's right. Yeah. So several states, led by Kansas, filed a lawsuit in Georgia. It's a little confusing. Georgia's also part of that, but Kansas is the lead state in the case. They asked for an injunction. They won, making very similar argument to the one I laid out. That what USDOL is doing here, they don't have authority to do, and they're essentially acting like Congress. Virginia was covered under the preliminary injunction that you discussed. Georgia, Tennessee, South Carolina. Everybody around us is covered by it except for us. And we decided on behalf of our farmers, we need to step in and bring our own lawsuit, and that's what we did.
Okay, so this is the fun part, but what's the timeline and all this? And I know that can be...
Yeah, we are in the process of thinking through strategically how we're going to handle it. We would like to get a ruling by the end of the year. It's going to take a little bit of pushing to get that, but our goal is to get this teed up, get it briefed pretty quickly. Next couple of weeks, I would expect for us to submit. We've already filed the lawsuit, but then we would submit the paperwork or the legal arguments that go with it in the next couple of weeks, and then hopefully the judge will do a hearing sometime in the fall or late fall, early winter, and then we can get a ruling. Again, like I said, the goal would be the end of the year, but if that's not successful, January would be okay. Most of our H2A workers come in, or the applications for them are starting to be filed in January, February, March. So that's really where we need the ruling.
Trying to get it before all that.
Correct.
So they wouldn't be. So I guess it's as of right now, they would be affected unless we get a ruling.
Yeah, we have not asked for a preliminary injunction. The rule is in effect in North Carolina, but the actual number of people who are hurt by it at the moment is not very great. But it's going to get big down the line here in the next couple of months.
Jake, thanks so much for giving us an update on this, and just let us know what the next thing is and comes along, because a lot of people are watching this for sure.
Absolutely.
All right, thanks, Jake.
Thanks.